speaking with me, Tarun Nangia. Justice Chandrachud made a very important comment during the course of hearings recently. He said that the news media cannot be stopped from reporting on oral observations made by judges in the courts. Now, we all know that judges in the course of trials, as also when cases are heard, have made very important observations, of course, a lot of times in response to the arguments made from the bar. We, in a sense, media and also the people of India have benefited from these opinions, and people have been informed of what happens in the courts through these deliberations. These are important in a democracy, and Justice Chandrachud, in a sense, has upheld these values when, in response to a plea by the Election Commission, he said this. Today, we're going to focus on the importance of what Justice Chandrachud has held and discuss our show today. We have a very eminent panel today. I have with me Senior Advocate Salman Khurshid. As we all know, sir has served as the External Affairs Minister of India, as also the Law Minister of India. Thank you so much, sir, for joining us today. We have with us Senior Advocate Gopal, Jain, who joins us on the show today. We also have Ruby Ahuja. She is Senior Partner with Karanjawala and Company. Thank you so much for joining us. Let us begin with the first round of opening comments. May I request Mr. Khurshid to open the show with his opening comment?
Well, I think that this is very refreshing, and I hope that this is an opinion that cuts across the judiciary. We are in fact very disadvantaged in a sense because we never have an entire court give us an opinion, whether it's a formal judgment or it's a passing comment of this nature, because of the manner in which our benches are organized. But I think what Justice Chandrachud has said is very welcome. It's very refreshing, and I think it's part of a tradition that he is at the forefront of, and that's a tradition of liberty. I mean, he's taken such pains to amplify the idea of freedom, the idea of liberty, the idea of autonomy, dignity. And I think this is part of that. So there isn't a distinction in his mind, as it appears, between formal positions that you take in law, the rule as it were, and the general demeanor, the manner in which you conduct yourself, whether it's in court or it's in real life outside court. And I think this is wonderful, extremely refreshing and very welcome.
Extremely refreshing and welcome is what Mr. Khurshid says. I'm going to Senior Advocate Gopal Jain, sir, your opening comment on this show.
Well, I think very timely comments in the context of an era of open governance, transparency, and very soon we are perhaps going to see live streaming of court proceedings. So it's almost like it's there for everyone to see and for everyone to hear. Second, I think the flavor of what happens in court can only come when everything collectively is put out there for people to see, to observe, and to note, because it gives the full context, it gives the dialogue, it gives the engagement. And see, it's fresh air, because courts say, look, media and us are related. They are the best form of dissemination of what happens in the courtroom at present. They must have full access to what happens, and they must have full liberty of reporting everything which transpires in the course of a hearing or perhaps a courtroom drama. And I just want to add two things here to this. There's a sense of responsibility both sides, be it a bench or the media. And second, sometimes things happen in the heat of a moment. And I think responsible journalism really means you report it accurately to make sure that what is newsworthy is communicated, not just for the bite value. And likewise, when courts sometimes make comments, scathing at times, it's perhaps the pain which they feel or the situation, and the oxygen and all the recent cases are great examples of that. So if a court sees what's happening around itself and in society, these things find a form of expression. Not all are recorded in an order, but all are important, as I said, to give the entire context flavor so that the viewer and everyone else gets to actually experience what happened in the courtroom in that case. So it's a very good welcome step in line with the times.
Okay, a couple of important points by Senior Advocate Gopal Jain. I'll now go to Ruby Ahuja from Karanjawala and Company. Ma'am, your opening comment today.
Tarun, good evening. I don't think so. I can differ either with Mr. Khurshid or with Mr. Jain that this is a perfect time. There wouldn't have been a better time for court to come up with this judgment and these observations which we are discussing today. There has always been a demand, and in fact, we have followed open, transparent manner of court proceedings. The court have been accessible to everybody. When we used to have physical hearings, everybody could walk in and observe the court proceedings and report. Barring those in-camera proceedings in rarest of rare cases. So, of course, this is very welcome, and our democracy has this facet of transparency, which is very, very important to all of us. But having said so, I think, which Gopal has touched, that on the other side also the responsibility lies. What happens, I don't think so anybody has, even the judiciary or anybody has a problem in reporting the law, reporting the judgment, but reporting a comment here or there which happens in court where, sometimes in the midst of a moment or when court is asking a question, a counsel is answering. And, then I do have a problem with picking up one line and, sensationalizing it. So I think somewhere we will also have to be cautious that there is a difference. I'm not saying censor. So there's a very thin line, censor or sensationalism. What do you want to do? You do not want censor for sure, but you do not want sensationalism also. We all know that one line tucked in by any, honorable judge or any by senior counsel while answering to the court runs whole day in TV channels. There will be some 30 debates for 3 days. And I don't think so anybody will report or write that this is not part of the written judgment. Even if somebody will, it will be like, those mutual investments somewhere tucked in at your own risk and cost investor. So I think this is very welcome, and we all are very happy that it's happened. But I think the other, side also needs to weigh a little bit. I'm not saying don't report, no censorship, please report, democracy, media, very important. And this is the time when we need every limb of the democracy to come forward to, protect what we have. So I think, sorry, that some balance, and that's it.
I'll go to Mr. Khurshid. Justice Chandrachud said that what happens, the discussion between senior advocates and the bench is of public interest. The comments and the observations made are of public interest. And the people have a right to know about this dialogue that happens when the advocates are arguing a matter and the judges are commenting. What do you have to make of it, and how do you feel about this statement?
Well, I think this is consistent with our ideology as far as the judiciary is concerned. Courts are open places. They are accessible to ordinary people and must remain so. I know that in recent years, there have been concerns about overcrowding. There's been concerns about security, and therefore the system of rationing number of people who can go and where they can sit and passes that have to be made. Those are all understandable, but principally the ideology is that you're open, that justice must be done in an open space and justice must be seen to be done. And I think this is very consistent with that. The problem we had with our system was that they were very high stated aspirational principles that we talked about. But when it came to actually doing things, we found them inconvenient and we therefore cut corners. I think this has often happened in life. You say something, you do something. That, in the language that's used in our political circles is about karni or kathni, that you say one thing and you do something else. Now, this is, when I use the word refreshing, it's because whatever is the stated aspirational principle, when you sound very good, you sound very very elegant and you sound very noble, you are actually seeing this on the ground. So the point that Ruby made was, I think, very important, that one word out of place or out of context could lead to a huge situation which is unwholesome. But the fact is that here is a judge who is showing courage of conviction, that if you believe in something, then knowing that it may go wrong on a particular day, you still will allow it because you believe that is the right way to go forward. It's like your criminal law principle that even if 11 people go unharmed who are guilty, but one innocent person must not be harmed. That is the manner in which I think the spirit in which this has been said, and I think is extremely welcome. But there are many more things that need to be done. I think if you believe in this kind of openness, you'll also have to do away with a lot of the sealed envelope jurisprudence as well. There's too much of that. I believe it may be necessary in extreme cases, but I think there's too much of that, frankly.
Okay. Point well taken. Sealed envelope jurisprudence is something we heard a lot in the recent 2-3 years. We hope in the future we won't see much of that. But as they say, sunlight is the best disinfectant. Senior Advocate Gopal Jain, isn't it true? Sunlight is the best disinfectant. So, in a sense, media reporting everything that happens in the courts only furthers the cause of democracy in India.
Yes, absolutely furthers the cause of democracy as well as the whole system of hearing. The whole purpose of hearings in court, in open court, as they say, is really the equivalent of sunlight. People should see exactly what happened. And I think this is a very good, bold step. And as Salman rightly said, it should now extend to various other facets of the decision-making process. For example, even contempt sometimes people fear. So you should equally then allow a very robust criticism if the need so arises. And likewise, sharing information transparently with parties, with the court, versus putting something, under the cover of darkness. That is not a disinfectant at all. But I think the important message which goes here is courts and media can come together and work harmoniously and collaboratively. And it shows a sense of a strident court that, look, it's for all of you to see and judge. We are very open. So there's another facet or a dimension to that. And likewise for litigants all over India, particularly now with this online virtual hearing as well, we do pick up so many things which otherwise people wouldn't have picked up. So all of this in the present context, in the times that we live in, furthers, as you said, good democratic principles, and most importantly, as I said, open court and opening court to media completely.
That's a good thing. In fact, some officer in the bureaucracy thought it was fit to move the Supreme Court. And he could even conceive such an idea that from now on, journalists will just report on judgments. Is the reason why we could get such a good observation from Justice Chandrachud. Had this gentleman bureaucrat not thought of such a thing, we would not have been able to elicit such an opinion from the Supreme Court. It has, Gopal, you have to say something.
And this Supreme Court, by the way, in the Sahara case, way back in time, had also at that time said something similar. So they've been fairly consistent. This is taking it further, much further. But just to put it in context, they had an occasion to examine it way back in the Sahara case. But again, they had permitted wide scope coverage of proceedings.
Ruby, in your law firm, you happen to represent some high-profile clients. You engage a lot of seniors. The stakes are pretty high when these people appear in court. And of course, anything going one or the other way, you as somebody who briefs or engages counsels, the impact is also on you because the play of media has become so big. In that part of a thing, though media has a right to report, what do you think becomes essential? I mean, is there always a certain fear that, one kind of view may dominate in the media or is this something that plays in the law firm's mind ever?
See, let me tell you pretty much the problem which arises, as Gopal used the word, it has to be open. Now, what is it? It is open and seamless. There are no boundaries around it when, the reporting happens. And even in I have no problem in people reporting, anybody writing an article, anybody giving an interview. I don't even believe in it. I mean, our firm believes that when a matter is live going on, our normal advice is please do not go on TV and start giving interviews to our clients. But if somebody has a contra opinion, please, no problem with it. But what my problem is that when people start dissecting every judgment, not on law or on the case law, but you make it a very, very personalized opinion about the judge, about why that judgment has come, there I think the problem lies. Then you are creating some sort of through the media route. I'm not saying that, through this, your open discussions, debates, you are creating some sort of an atmosphere where even the judiciary has to step back and think before, coming up with a judgment. Because, sometimes you feel that one judgment and everybody, you may not believe in that judgment because it may not be the public perception, but it may be a good judgment in law. So I think there is the problem which I have, because you may think that somebody needs to go in jail because, there is a media hype. I'm giving as basic an example like that because a media hype is created because that person has done act A or has done an act B because whole day for 48 hours, we have been shown his photo, his film, and then I mean, right now, one case is going on in the country. I don't want to name it, but the whole hype around it is that, has that guy done this? Has that? But the problem is that you then don't allow the court to work around to the, level of law, case law, sections. You want the public perception should become a judgment, which is very dangerous. It is very, very dangerous. It is not a good thing for democracy. That is why we have judges. That is why, those judges go through years and go to the Supreme Court and you choose some because you want them to judge on the basis of law, on the basis of, what has been legislated. That is where that is where my fear lies. And I think that is what media has to be careful that are we encroaching that path in some cases?
Let's go to Mr. Khurshid at this point. The Supreme Court also said this, that the High Court judges, they, as in the High Court judges, are also humans and they are also stressed. Take this issue in the correct spirit. We don't want to demoralize our High Courts. They are vital pillars of our democracy. Things are often said in an open dialogue between the bar and the bench. Sir, you spent so many years in the courts. You've also been in the government. You've seen in the other side also. How important is this dialogue between the bar and the bench, which happens while they are arguing in court? And also its importance to be reported in the free and fair press?
Well, interesting because, every field has people who have a special interest. And as far as the legal field is concerned, we know that there are a lot of reporters who are particularly specifically attached to law. They report law, they have a culture of reporting of law. They understand the parameters of reporting. They develop their own special field for what judges do and how judges do it. But I have in mind something that is not being thought of as yet in our country, and it may invite different opinions. But the American Supreme Court, for instance, has a public relations officer. He has a public relations officer who makes statements periodically, authorized by the Chief Justice, which add an authentic flavor to the reporting. So you can say that I have spoken to somebody who was authorized to say this. Of course, one will have to be careful that a person who's a spokesperson doesn't end up adding to what the judges would be saying, and should not become an additional judge, as it were. But that, of course, by training and by culture, that would become manageable. But I think it's important because in India, there's a lot of speculation that happens. Why did this person get off the bench? Why was this person not there? Was this really the intent? Was he really angry, etc., etc.? many of these things can be properly and objectively and carefully explained by an experienced person. And if the court felt that something extra needs to be said, the court would give such instructions. Right now, because the judges cannot amplify, they cannot explain, they cannot articulate anything except in an indirect way when they have an opportunity to deliver a lecture somewhere and so on. But in the immediate vicinity of what has happened, they are unable to articulate and explain. That is something that a spokesperson on behalf of the court could do. It could be a trained judge who also is a trained spokesperson and a media handler. Maybe someone who could do something like that. But I believe the time has come, given the extent of media scrutiny and media interest, time has come to have a spokesperson for the courts.
But moving ahead, sir, you've also spoken about something which is known as difference of opinion on the bench. You know, when judges disagree, I remember you telling this to me a couple of years ago, that judges disagree each with equally reasoned arguments, and then finally one judgment is given. Now that kind of discussion which happens when the cases are being argued, and you know there can be two rights also sometimes. Do you think it bodes well when that kind of reportage also comes out? Because a judgment may go one or the other way. It doesn't mean that the other party was wrong.
Yeah, let me just say two things that I find particularly interesting, and I hope that my colleagues will comment on that. If you look at American Supreme Court judgments, if there is a disagreement between judges, they argue it out in the judgment itself. So you have the main judgment and you have a dissenting judgment. The dissenting judgment takes up the argument that's put in the main judgment and answers it and says, no, this is not right. This is not to be seen in this manner. Our judgments don't do that a lot. Our judgments take their own line and then just take off in that direction. So they don't come back to say, I'm sorry, but what you've said here doesn't hold ground because it's inconsistent with something else, and so on and so forth. And I think that's probably because there isn't enough time. Although our judges now are equipped with very good support staff, and they have interns who help them and who are very, very bright. But this is one thing that is lacking. So the dialogue that you want to hear and you want to read and see, that dialogue doesn't happen. The other thing is, and it perhaps can't be done immediately, but it'll have to be done in due course, as you do have in the American courts. You have subsequent writings or books that disclose what happened at the meeting of the judges. Not immediately, but it may be 5 years later, it may be a few years later. Somewhere the history must be clear. Now, we have a lot of good history written about top judgments in the country, like Kesavanand Bharati, and we know the kind of anecdotal information that the Prime Minister had called so-and-so and the Law Minister had called so-and-so, and then the judgment came, etc. But what you don't have an authentic record given perhaps by the interns or by somebody who's been authorized in due course for a better historical understanding. But this is obviously something that can't be done straight out of the oven.
Point well taken. So I'll go to Senior Advocate Gopal Jain at this point. Your opinion on this? You're not audible.
Well, two things straight away. I think we are in an era where we have communicating courts, in an era of communication and social media. So I think Salman's idea that the court has a spokesperson who actually sums it up and gives a correct perspective which is balanced and which is then disseminated across the spheres in India and abroad, like with governments and embassies and all that, is an institutional way of dealing with sharing of communication and reportage of what happens apart from what the media does. So like they say, there's an official spokesman, and so you get to hear it from him, and then you have media reportage and coverage in any case. So one will have both. So I think that's a very good idea, particularly with so much of social media, both scrutiny and comments on court. I think it's all the more important in that noise to have a recognized spokesperson who gives the version. And second, I think I've always firmly believed that you need to record history as, for example, if you take the Ahuja judgment, it was the judgment of the court. So it would truly be fascinating, as Salman said, to know what went into it, how different minds got together, who actually wrote the judgment, or was it a collective effort, and a lot of thinking which goes behind it. I think that's very, very important for jurisprudence and historical benchmarking, like when we turn to archival materials, right? So it may be dated 5 years or some such thing, but I think that's something which is really necessary. And all this is the material and in a communicating court, which I think makes for good understanding of legal systems. And most importantly, people go to court because they're in some form of pain, as we've seen in recent times. So it's very important to have a very engaging debate and dialogue, open. That's why it's live. And to your point, why do we have benches? We have benches because we believe difference and diversity and divergence of opinion makes for good decision making. So all of it must be holistically covered so that all angles and perspectives are known to a reader or viewer, and most importantly to the litigant. So right to know is as much a part of this as information sharing and reportage. And these are all good signals coming from the court that it's really moving in that direction. And two suggestions that Salman has given, I think, will take it even further in institutionalizing the whole thing. I am also a firm believer, by the way, that the court should also have a social media handle, because that's really where the millennials look to. So why not, in the information age, why not also be tech savvy? We've already moved to virtual and online hearings. So that's another very important medium that the court should cover.
Be open, communicate even via social media is what Senior Advocate Gopal Jain says, but we can't thank the court enough today on this show, Justice Chandrachud, especially this time, because I'll give you an example in about 30 seconds from now. See what happens. This is a continent-sized country. There are hundreds of newspapers in Kerala, Karnataka, Tamil Nadu, Andhra Pradesh, Odisha, Northeast. They also want to report. A lot of issues are not relevant in Delhi, but very important to those states. They are being argued in the Supreme Court. When, because of live hearings, which are going to happen in future, we presume, a lot of instant reportage and a lot of feedback can grow that our case is being heard in the court and people will benefit. So in a sense, what Justice N.V. Ramana said as to live streaming of court proceedings, and now what Justice Chandrachud said that, media can report, will go a long way in entrenching democracy in this country. Ruby, your comments on this?
Just to tell Mr. Khurshid, I think what I have read, day before yesterday, in fact, Chief Justice Ramana has, while he launched that app for media people, he has said that while this live proceedings, he's looking very seriously on this issue. They are also going to appoint an officer of the court who will be, a connecting person between the court and the media, so that media is not into some difficulty, and as it when they want some clarification, they can speak to him. So that is, I think, in the pipeline, which will be, if not like a spokesperson of a corporate, but will still be on those lines. And having said that, I agree with both Mr. Khurshid and Mr. Jain that yes, it will be a good idea to know what goes on in judge's mind, which judge said what in a 5-judge bench judgment or a 7-judge bench judgment. In fact, I also feel that sometimes, why even constitution bench judgment, that of course is on very serious issues. Even if our Supreme Court has the power of review, which is there in our rules, and, there are review petitions filed, I have never understood as to why review petitions are listed in chambers. This logic, I have never, either you have a power of a review and an option you give to a litigant to review, or you don't give an option. You can say, Supreme Court, you file an SLP, civil appeal, judgment comes, matter closes. But we have created 2 more steps. We have created a step of review. We have created a step of curative. I have not understood why should review petition be decided in chambers. So, I think this is as basic as that. So I think, yes, of course, I agree. Little open, transparent is not a bad idea. But just to answer Gopal's question of having a social media handle, Gopal, you have no idea that what sort of things people write on social media handles. It will become very unguarded. And I don't think so you will even like it as a lawyer and an officer of the court to see that path and see that route. So I will be very wary of Supreme Court having an official Twitter handle or or an Instagram page or a Facebook page. I don't think. We are a mature democracy for sure. We are, and our newspapers, TV, our journalists have done great job. We have had some very good editors. So, but I think we haven't reached that. Let's not go that route. I will like to keep it formal.
No, point well taken, Ruby. One closing comment from Mr. Khurshid. Sir, your closing comment on the show today.
A closing comment is that I wish the benches would agree so easily as we've agreed here on everything. What we need is to pick our judges more carefully. They'll agree on all sensible things, and we'll have a good time in the country. Too many unnecessary disagreements, although disagreements are wonderful things because disagreement allows you the true essence of democracy. But I think that disagreements also do create a lot of problem. And as Gopal said, the Ayodhya judgment almost created a disagreement because there is the judgment which is unanimous, and then there is a draft judgment which we don't know has come from where. But if that draft judgment was also delivered as a dissenting judgment, then there would have been a very serious problem.
Point very well taken, Mr. Khurshid. So this was, in a way, we had a chance to thank the Supreme Court because of the kind of observations that they did. It helps the media, it helps democracy. I'd like to thank so much that Senior Advocate Salman Khurshid at a short notice consented to join us for today's show. Thank you so much, sir. Thank you so much, Senior Advocate Gopal Jain, for joining us. Thank you so much, Ruby, for finding time and joining us on the show today. Thank you, viewers, for watching Legally Speaking today. Thank you.
And thank you, Tarun, for making a topical show. Timely and topical.
There are only two people there who can become judges.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.